Okay, for our first topic for this course, let us discuss the nature, form, requisites, warranties, earnest money, and option money in the contract of sales. Of course, this discussion is in accordance with the details embodied in the CPA licensure examination terms of specifications and syllabus that will be effective in the year 2022 examinations. Okay, so we will be discussing these topics in accordance with that um, TOS and syllabus. First things first, let us define what is a contract of sale. Okay, under Article 1458, by the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. Take note, class, that a contract of sale, in a contract of sale, the thing to be delivered must be determinate or at least determinable. Okay? You should relate this to your obligations in contracts on the topics of determinate and indeterminate thing. Okay? So for the contract of sale, the thing to be delivered must be determinate or at least capable of being determinable. Okay? And the price must be a certain in money. Okay? The price certain, ibig sabihin, the price must be fixed in terms of money or its equivalent. Okay? Which may be in other currencies. But the price must be certain in money or its equivalent. Take note, class, that this subject is a continuation, supposed to be a continuation of your obligations and contracts, while that the 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 topics in obligations and contracts are applicable to all types of contracts. The contract of sale is one of those contracts. Okay. Specific contracts, I mean, where we where the principles of the obligations and contracts will be applied. Now, this time, we will apply those principles in a specific contract called sale. Okay. So while in your obligations and contracts, the topics there is are very general. Okay. Now in your second law subject, we will discuss the specific contracts embodied under also the civil code, and the first one is the contract of sale. Okay, so then after this one, we will discuss pledge, mortgage, real mortgage, and chattel mortgage. Okay, these are specific contracts. Okay, otherwise said, we will discuss and we will get to know each and every specific contract. Okay, I call them specific contract because they are particular contracts that has been discussed by under the civil code. So that is the definition of the contract of sale. So before the contract of sale may be entered into, there are stages. Number one is the negotiation, or other authors would call policitation. Okay. Of course, in the negotiation, okay, you talk about the parties. We'll talk about the thing, its characteristics, qualities, and then there will be negotiation as to the price, okay, other conditions that may be agreed by the parties. Okay, it is in this negotiation stage where the offer of the seller will be conveyed to the prospective buyer, and the buyer could either make counter offers or impose conditions on the seller. Okay, so once the offer is accepted, then there is already meeting of the minds, in which case there will be a perfection of the contract of sale. Take note, class, that the contract of sale is a consensual contract. It is perfected by mere consent. In short, there is no need yet. Once the parties agreed on the price and on the subject matter, okay, the contract of sale is deemed to exist on that stage, okay, even if payment has not yet been made, even if the object has not yet been delivered. Okay, the mere meeting of the minds will perfect the contract of sale. Number 3 is consummation. This is the stage wherein the subject matter is delivered and the price is paid by the buyer, in which case the contract will already be consummated. In short, it will be completed or consummated in that stage. So who are the parties to the contract of sale? Of course, the vendor, also called the seller. He is the person who has the obligation to deliver the thing, and not only to deliver the thing, but to transfer the ownership of that thing. Okay. The other party is the vendee, or otherwise called the buyer. Okay. This is the person who has the obligation to pay the price. So if you look at this presentation, both the vendor and the vendee has his own obligation. Okay. That is why, class, a contract of sale is a bilateral contract. It means that both parties have their own respective obligation. So if you relate this with your obligations in contracts, and you have to look who is the the active subject or the obligor, and you also have to look into who is the passive subject or the obligee. Okay, you have to determine who is the debtor, the creditor. And because this is a bilateral contract, you have to look into two perspectives. Okay, from the point of view of the vendor. Okay, from the point of view of the vendor, he has the obligation to deliver the thing. So in that case, he is the debtor. Why? Because he has the obligation to deliver and to transfer ownership. Okay. So from the point of view of the vendor, he is the obligor or the debtor, or no, obligee, or the debtor, and the buyer is the active subject or the obligor, because he is the one who can demand the performance of the obligation, which is to deliver the thing and transfer its ownership. Okay. That is from the point of view of the vendor. But from the point of view of the vendee, okay, the vendee, from the point of view, the vendee has the obligation to pay the price. So insofar as the obligation to pay the price, okay, the vendee is the debtor or the obligee, because he is the one who has the obligation. And from that point of view, the vendor is actually the creditor or the obligor, because he is the one who has the uh, the right to demand the performance of that obligation to pay the price. Okay, so bilateral sa class. So you have to look into which perspective are you referring to. So whether if you are asked the question who is the active subject, passive subject, or the debtor, creditor, you have to discuss the two perspectives. Okay, so that you will be correct in your answers. So what is the nature of the contract of sale? Number one, as discussed, it is consensual. Okay, it is perfected by mere consent when the parties agreed on the price, on the subject matter, then it is already perfected. Okay. In contrast, ang kabaliktaran ng consensual is real contract, wherein a real contract is perfected by delivery. Okay. You have to take note, class, that we are talking about a contract, not an obligation, because there is also what we call the real obligations. If you can still remember your obligations and contracts, real obligation is an obligation to give, which in this case, okay, in the contract of sale, the obligation is real obligation because the obligation is either to deliver the thing or to pay the price. Okay, those are real obligations. But the contract itself is a consensual contract. It is not a real contract. Why? Because the contract of sales is perfected by mere consent and not by delivery. Okay, so you have to distinguish that. Although the real the obligations involved in the contract of sale are real obligations, which are obligations to give, the contract itself is not a real contract but a consensual contract because it is perfected by mere consent and not by the delivery of the thing. Number 2, as also discussed, contract of sale is bilateral, meaning that the parties have their own respective obligations to fulfill towards each other. So, kanya-kanya sila ng obligations. It is onerous that the thing is sold in consideration of the price. Okay. In contrast, kabaliktaran niya is gratuitous. In gratuitous, there is no consideration or price because the consideration is the generosity of another. Example is donation, walang price. So, gratuitous. But in a contract of sale, because there is a price, the contract is onerous. Number 4, commutative. The thing sold is generally considered equivalent of the price. Okay. What you give, the value of what you give is the value of what you will receive. Okay, that is the general consideration. But there are sales that are what we call aleatory, which will be discussed later. Okay, that what you bought is not the same value as what you receive. Okay, that is the distinction of a commutative and an aleatory contract. Nominative, okay, from the root word nom or name. Okay, it is the contract of sale is nominative because the law itself gave it a name, which is sales or contract of sale. Yun ang pangalan niya. Number 6, the contract of sale is first principle, meaning it is a contract that can stand alone and is not dependent upon another contract. To compare, okay, like in a mortgage, you need a contract of loan so that, and which will be the principal contract, so that the accessory contract of mortgage can stand. Okay, there is no contract of mortgage unless there is a contract of loan, because the contract of loan is the principal contract, and the contract of pledge is the accessory contract. In the case of sale class, sale is a principal contract and not an accessory contract because contract of sale can stand on its own as a contract. So, what are the essential requisites of the contract of sales? You have to relate this to your obligations and contracts, more particularly on sa contracts. Okay? Yung COC, consent, object, cost, or consideration. Okay, it's the same as your essential requisites of a contract. It is applicable to the contract of sale because sale is a contract, and therefore the elements of contract in your previous subject is also applicable here. Okay, so let us discuss each and every requisites as applied to sales. Number 1, consent or meeting of the minds. So all contracts must have consent or meeting of the minds. In a contract of sale specifically, these are the most important things to bear in mind. Number 1, the contract of sale is perfected at the moment there is meeting of the minds. That is why it's consensual. So upon the thing and the price, meeting of the minds as to the thing and as to the price. From that time on, there is already consent. There is already a contract of sale because sale is a consensual contract. From that moment, the parties may reciprocally demand performance subject to the provisions of law governing the form of contracts. Okay, that's what is provided under Article 1475. Number 2, in case of public auctions, the auctioneer announces the perfection by the fall of the hammer. So, in the case of public auction class, consent or meeting of the minds is signified by banging the hammer. Okay, so when the auctioneer bang the hammer, that is the perfection of the auction sale. Kasi maraming mag-bid. Okay. So therefore, just like any other contracts, okay, parties to the contract must have legal capacity to contract, meaning they must be in legal age, okay, of sound mind, who made offers and acceptance in the contract. Okay, so meeting of the minds means there is an offer and there is acceptance by legally capacitated parties. So relating to your former subject on obligations and contracts, okay, we have studied that unemancipated minors, insane or demented persons, and deaf mutes who do not know how to read and write cannot give consent. But if they do, the contract will still be valid, but it will be voidable. Okay? But where necessaries are sold and delivered to a minor, necessaries class, ibig sabihin pagkain, shelter, medicine, whenever they are delivered, wherever these necessaries are sold and delivered to a minor or other person without capacity to act, even if they are minors, even if they are insane or deaf mutes, they must pay a reasonable price, therefore, because what has been delivered is for their, or sold is for their benefit. So these are valid. However, class, another provision of law is that sale between husband and wife is void. Okay. This was provided by law because there is another law which says that husband and wife cannot donate to one another. In the same manner, they cannot also sell to one another. Okay, sabi ito ng civil code. The reason here, class, are number 1, to prevent defrauding of creditors. For example, si husband may utang, marami siyang creditor. So para takasan yung creditors, he will sell properties to the wife so that the creditors cannot go after the properties. So the law, to avoid this, the law provided that husband and wife cannot donate and sold to one another. This is to prevent from defrauding creditors. Number 2 is to avoid a situation where the dominant spouse takes advantage of the other spouse by forcing the other spouse to sell all the properties to the dominant spouse. Okay. And to avoid the circumvention of the provision of donation between spouses. So dahil bawal mag-donate to one another, okay, to avoid circumvention, sale was also prohibited between husband and wife. Now, the Supreme Court said also that this is applicable also to common law husband and wife. To be fair, this is also applicable to common law husband and wife. Common law means those husband and wife na nag-live in without the benefit of marriage. This is also applicable to them. So the exception to that is that number 1, okay, when the husband and wife has a marriage settlement of separation, complete separation of property. Because under our law class, before you get married, okay, you can actually agree what will happen to your properties during the marriage. Okay. You can enter into a written contract which we call a prenuptial agreement. Okay. Sometimes, okay, the would-be husband and wife would agree into a complete separation of property. Meaning, okay, during the marriage, yung kay husband lang yun, yung kay wife lang yun, and hindi pwede ihalo. In which case, okay, if there is this separation of property agreed before the marriage through a prenuptial agreement, in that case, dahil separate yung property, they can sell to one another. Number 2, when there is judicial separation of property. Okay, when husband and wife mag-file ng legal separation sa court, then approved na ng court na ihiwalay yung properties, in which case, there is also a separation of property, the husband and wife can now sell to one another. Okay, on the topic of object or subject matter, okay, so the second element of the contract of sale is the object or subject matter. So there must be an object of the sale. Otherwise, there is nothing to be sold. Okay. Of course, as discussed in your obligation in contracts, the object of the sale or the subject matter must not be contrary to law, morals, good customs, public order, or public policy. Because if it is contrary, then it will be illegal or invalid. Okay. The object must not be impossible. It must be within the commerce of man. Okay. That is why you cannot sell the moon. You cannot sell the stars because it is not within the commerce of man. Okay. What is within the commerce of man are those things which are customarily involved, things that are customarily involved in the regular commerce and uh, commercial activities of man. Okay. And the thing must be determinate or at least determinable. As to the object, it is required by law that the vendor must have the right to transfer ownership of the thing at the time of delivery. Otherwise, if you look at your defective contracts, it will be unenforceable. It will be a sale of a thing by an unauthorized person, in which case it is an unenforceable contract. Okay, if you go back to your defective contracts, okay, if the vendor has no right to transfer ownership, then he is unauthorized, and therefore the contract of sale will be unenforceable. Take note, class, what is required by law is that the vendor must have the right to transfer ownership at the time of delivery, even if he is not yet the owner at the time of the perfection of the contract, when they agreed, when they had that meeting of the minds, even if the vendor is not yet the owner. What is required is upon delivery, at the time of delivery, he is already has that right to transfer ownership of the thing sold. Okay, so the requirement is not the right to transfer during the perfection of the contract. What is required is the right that the vendor has the right to transfer upon delivery. Transmissible rights may also be an object of sale. It is actually called an assignment. So if you have this particular land which owned by 2 or more persons and you are a co-owner, okay, you can sell your right to that land, that portion that belongs to you, and it will be called as an assignment of your rights to another person. Okay, because rights um, are invisible. A right is an invisible attribute. It is not tangible, it is intangible. That is why it's called an assignment. You're assigning that right to another person. When you encounter that word assignment or assigning of a right, it is actually a sale or selling of a right. And the right must be transmissible. Okay. You cannot sell intransmissible right like parental rights. You cannot sell your right as a father or mother to another. Transmissible rights are usually property rights over a personal or real property. Services cannot be the object of sale. Hindi mo pwede ibenta ang services. Okay. The proper contract for that is contract of services and not sale. Okay. So if you will become a certified public accountant later on, okay, you offer your services, the clients will come to you and contract your services. That is not sale, but that is a contract of service. Okay. Oh, this one is very important. Balik-balik sa board exam. A contract for the delivery at a certain price of an article which the vendor in the ordinary course of his business manufactures or procures for the general market, whether the same is on hand at the time or not, is a contract of sale. But if the goods are to be manufactured especially for the customer and upon his special order, and not for the general market, it is a contract for piece of work and not a contract of sale. Okay? So, kapag custom made class, for example, you have a very big foot and you want to to ask Adidas or Nike to make or manufacture a special shoe for you, a special pair of shoes for you to fit your very big feet. That is a contract of piece of work. It's like a contract of service, and it's not a contract of sale. Okay, because what is the thing involved here is not a thing that is available in the ordinary course of the business. It is not available for everyone. Okay, you are actually contracting a special kind of work for your very big feet. In which case, the contract is not really a contract of sale, but a contract for a piece of work. Okay. Please take note of this. This is very important. They always ask this in the board exam. This one also. Things having potential existence may be an object of sale, or what we call the sale of future things, or in Latin this is emsure sperati. For example, if you are a fisherman, before you go to the ocean or the sea, you enter into a contract of sale with your neighbor, and your neighbor promise that whatever you will caught, whatever fish you will caught, he will buy, and at the perfection of the contract, there is actually no present object yet because the object will still be caught, which is the fish. The law says that is valid and it's called insure sperati for as long as the thing has a potential existence. Okay? Things having potential existence may be the object of sale. It is the sale of future things, provided that the fish will be caught. Because if the fisherman will come to shore again with no fish in hand, then there will be no contract of sale because there is no object. Okay, what the law is saying that is that for future things can be an object of sale for as long as they have potential existence. Therefore, the sale is subject to that potential existence of the subject matter. The other one is emsius pay. Future things is emsure sperati, while selling hope or expectancy is called emsius pay. Okay, pwede pala ibenta ang hope, pag-asa, or expectancy. The classic example for this one class of emsius pay are lottery tickets, raffle tickets. Okay, you're actually selling hope. Okay, when you go to the Lotto outlet and you buy hope, you will get this piece of paper. Okay, nandun ang number mo. You're not actually buying the paper. You're actually buying the expectancy or the hope that you may win. It's like also with raffle tickets. May organization kayo, then you want to raise funds by selling raffle tickets, and then we will be raffling it in at a particular date. Okay, so the selling of those tickets is actually anxious pay, or the sale of hope or expectancy. What is important here, class, is that the condition, the law says that the thing is also will potentially come into existence. Manalo ka or matalo. However, the sale of vain hope or expectancy is void. Vain hope or expectancy, class, is, for example, you are selling tickets to a raffle that will never be made, or a raffle that has already been made, tapos na, tapos parang so that you can raise more funds, you sell tickets that has already been raffled. Okay, so that is void, that is vain hope or expectancy. Take note, class, the usual error here for accountancy students are they call the sale of vain hope as anxious pay. No, anxious pay is the sale of hope. The sale of vain hope is void. It is not anxious pay. What anxious pay refers to sale of hope, not vain hope. So the third requisite is cause or consideration. Okay. So technically, the cause in sale is, as to the point of view of the seller, the cause is the buyer's promise to pay the price. If you look into the perspective of the buyer, okay, the cause would be the seller's promise to deliver the thing sold. Because the contract of sale is a bilateral contract. You have to look into the two perspective. Okay. But generally, casually, they would say most authors will say that the price is the consideration of the sale. Okay, so requisites of sale is C, consent, O, object. Ang object is the thing to be delivered, and of course the cost or consideration is the price, which is certain in money. Okay, so if you don't want to be technical about it, if you just want to be generally correct, you say that the cost is the price and the object is the thing. But if you want to sound intelligent, okay, you say, as to the point of view of the seller, the promise to pay the price is the cost, while as to the point of view of the buyer, the seller's promise to deliver things sold is the cost. Okay, both statements would be correct. Just do not forget the point of view thing and the general application. Okay, some rules. If the consideration of the contract consists partly in money and partly in another thing, okay, ang bayad is in money and with something, with something that is not money, the transaction shall be characterized by the manifest intention of the parties. So you have to look into whether the parties intended sale or a donation. So if the intention of the party is sale, then that is sale. If the intention is not sale, then that is not sale. Okay, so the intention is what will prevail. If such intention does not appear, if it is not clear, then it shall be considered barter if the value of the thing is more than the amount of money. Okay? If ang value ng thing na pambayad din plus money, mas malaki yung value ng thing, then will be considered barter if you cannot determine the intention of the parties. Basta importante, number one, you have to look into the intention. If the intention is not clear, then you look at the value of the thing. If the money is more than the value of the thing, then that will be sale. If the thing is more valuable than the money, then that is barter. Okay, ibig sabihin nito, class, bibili ka ng isang bagay, ang pambayad mo, pera at saka isa pang bagay. So, ang pambayad mo dito is hindi lang pera, kundi money plus another thing in exchange for that thing na bibilhin mo. Okay, so This rule will apply doon. Titingnan yung binayad mo. Mas marami bang pera? O malaki ba yung thing na binayad mo? Okay. Basta ang important is you look into the intention first. Because the intention of the parties will always prevail. You only look into the value if you cannot determine the intention. Okay, another uh, uh, rule. Gross inadequacy of price does not affect the contract of sale, except as it may indicate a defect in the consent or that the parties really intended a donation or some other contract. Okay. There are cases ng good class na the thing is very valuable and the price is very small or less. So you look into the intention of the parties. If the intention really is to sell, for example, you are selling your cell phone for 2,000 pesos. Okay, may 2,000 pesos na phone. Okay, that would be sale if that is really your intention. But if it is not very clear, then you may have intended a donation or some other contract, in which case still valid, but it will not be a contract of sale, but some other contract, which may be donation. If the price is simulated, wala talagang price, then the sale is void. Why? Because there is no cost or consideration. Okay. But the act may be shown to have been in reality a donation or some other contract. Okay. There are cases kasi class na you do not want to make it appear na donate mo. Sabi mo dun sa kausap mo, palabas lang natin na binayaran mo. When in fact there is no price really, then there is actually no sale. But the contract is still valid, but not as a sale, but as a donation or some other contract. Okay? Simulated price ang sabi dito. The sale is void, but it may be a donation which is valid. The fixing of the price cannot be left to the discretion of one of the contracting parties. Hindi pwede isa lang ang pa-decide. Discretion of the one of the parties. The price must be agreed upon by the parties. Okay? Para magkaroon ng consent. Okay. Because if the price is not yet fixed, when the parties agreed, then there is no cost of consideration. Because the cost in consideration is one of the essential elements of the contract of sale. So if there is no price, then there is no cost of consideration. Then the requisites of sale is not complete. But if one of the parties fixed the price and accepted by the other, then the sale is perfected, of course. Okay. What is prohibited by law is walang price. Nung nag-agree ang parties, walang price. Therefore, walang sale. Okay. But once the price is fixed by the one from the party and accepted by the other, then there is already sale. Okay. Aside from the essential elements of the contract of sales, which is COC, consent, object, and cost or consideration, there is also what we call natural elements of the contract of sale. Okay. While the essential requisites are very important and should be complete, hindi pwede kulang yung COC, there is another element called the natural elements of the contract of sale. This is called natural class because whenever there is a sale, it would follow that these elements are also present, even if you did not agree on it. Okay. The law says that whenever you enter into a contract of sale, there must be COC to be valid. And another is the natural elements. These natural elements are considered part of the contract, even if you are not aware of it, even if you have not agreed on these elements. These are those which are deemed to exist in the absence of any contract, like warranty against eviction and warranty against hidden defects. Okay. Itong mga warranties na ito, which will be discussed later in the slide, are deemed to be included in the contract of sale, even if you did not agree on it. Ang pwede nyo lang gawin is i-waive. Okay, you can agree na, okay, buyer, seller, we agree na wala nang warranty. Pwede nyo waive. Okay. Sir, what if, sir, gi-stipulate pa rin namin? With more reason na valid siya. nakasama sa contract. Okay. What we are saying here is these natural elements are essentially part of the contract, even if there is no stipulation. If you stipulate on it na included siya sa contract, with more reason na included siya sa contract. Okay? What you can do is you can waive this para mawala siya sa contract. You can waive this. You have to waive this expressly. If there is no waiver, there is no stipulation, silent lang ang contract, then this natural elements is considered part of the contract. Okay, warranty. Let us look at this warranty para dugtong doon sa discussion. Warranty is any representation made by the seller that the character, the quality, or the ownership of the thing is okay and good, so that he can induce the buyer to purchase it. And the buyer, of course, rely on this representation. Then, there are two kinds of warranty. The express warranties. So, ano yung pinagyabang ng seller? Included yun. Kasi express yun eh. Sinabi niya. Number two are those implied warranties. Yung kanina. Warranties against hidden defects. Warranties against eviction. Yun ang implied warranties. Implied warranties, from the term implied, okay, you need not agree on this. These implied warranties, which are natural elements, are deemed to be included in the contract of sale, even if you did not agree on it, because what you can do is only waive them. So let us look at the implied warranties. If there is an implied warranty, the law says there is an implied warranty that the seller has the title and he can transfer the title to the buyer upon delivery, which also means that there is an implied warranty against eviction. Okay. Warranty against eviction class is that when you bought something, the thing will become yours, and no one can take that away from you. You will not be evicted from that possession. Okay. Because the seller is actually, this is mine, I sell this to you, and because you bought it, that will become yours, and no one will take that away from you. That is one implied warranty. This is called this is popularly called warranty against eviction. Okay. Kahit walang word na implied, basta warranty against eviction, that is an implied warranty. This is also called implied warranty as to the seller's title. Okay. The seller is actually guaranteeing that he has the right to sell the thing and to transfer ownership to the buyer, who will not be disturbed of his legal or peaceful possession thereof. Okay. So that kapag you are the buyer and someone claimed the thing and you are stripped of the possession of the thing, then you can go after the seller for breach of warranty. Okay? Bili ka ng cellphone. The seller said, this is my cellphone and I will transfer ownership to you. Once the cellphone is nasa iyo na, then someone claimed it to be his or her, and you are, the possession is stripped from you. Ibig sabihin, kinuha yung thing. Then you can go after the seller for breach of warranty. The seller says, "Oy, I did not give the warranty that you will be dispossessed of the thing." You can say, "Oh no, even if we do not agree on that warranty, the law says that it's an implied warranty. Even if you do not agree on it, that warranty against eviction exists and is part of the contract. And because you have not waived it, then you can claim it." Take note, Lasa, this warranty is implied. It is considered part of the contract of sale in accordance with law. The second warranty is warranty against hidden defects. The seller guarantees that the thing sold is free from any hidden faults or defects or any charge or encumbrance not declared or known to the buyer. Okay. Take note, last, that the defect must be hidden. Okay. This is actually not applicable sa second-hand items. Why? Because sa second-hand may mga hidden defects na yun. But this implied warranty against hidden defects requires that the defect must be hidden. Because if it is very clear that there is a defect and still you bought it, then you cannot claim warranty against hidden defects. Okay, number one, the defect must be hidden. It is not known to you. Okay. Later on, when you bought it and you open it sa bahay, then you found out that the defect, there is a hidden defect. The defect must be substantial. Okay. You have to inform the seller of this defect, and you can claim warranty against these hidden defects. The seller cannot say, "Uy, we did not agree on that, that there will be a warranty against hidden defects." You can say that, "Oh, this is an implied warranty, and the law says even if we do not agree on this warranty is considered part of the contract of sale." Okay, and because you did not waive it, then you can claim it. And if there are hidden defects, then you can go after the seller for breach of warranty. Okay. If ayaw niyang tanggapin, then you can sue. You can file a case against him in the court for breach of warranty. Hindi breach of contract kasi breach of warranty. Number 3 is implied warranty as to fitness or merchantability. Ibig sabihin, that the seller guarantees that the thing sold is fit for its purpose, or if it is bought by description, ang i-describe lang sa iyo, binili mo. Okay. The buyer guarantees that it is of merchantable quality. Ibig sabihin that the quality of the thing is fit for commerce, fit for selling to another. Okay, so these are the 3 implied warranties. Which warranties, take note again, are implied, considered part of the contract of sale even if you did not agree on it because it is provided by law. What you can do is only to waive it. If you do not want this warranty, then you can waive. But if you will not waive it, then you can claim it later on as part of the contract of sale. Take note of those implied warranties, very important. Tatlo yan. Okay, take note of this also. Implied warranties, yung tatlo are not applicable to as is where is sale. Okay. Usually this as is where is sale are sale of surplus products. Okay. Okay. When the seller says as is where is, okay, whenever the thing is located, whatever is the condition of the thing, will be buying it. And therefore, there are no implied warranties because you know that those are surplus products and they may have defects, they may have claimants. Okay, so you buy it on your own risk. Number 2 is those warranties, the implied warranties are not applicable to second-hand articles because second-hand articles may have already defects and may have been claimed by other persons. So if you buy this at your own risk. Sale by virtue of authority in fact or law. For example, plus an example sa classic example number 3 is si sheriff. Okay. Si sheriff kinuha yung properties ng isang person because of court order, then sold it at public auction. Then the sheriff does not make these implied warranties. Okay. You cannot go after the sheriff for breach of the implied warranties because it is sold by virtue of authority in fact or in law. So my exception. These are exceptions to the implied warranty. Caveat emptor, because of this warranty these implied warranties, these exceptions, yung as is where is, second hand, yung sold by auction, okay. There is a principle called caveat emptor, meaning let the buyer beware. So when you are the buyer, you have to be very careful. You have to inquire as to the thing to make sure that you are buying it at lesser risk. But this caveat emptor is actually embodied in the old civil code. Naturally, because the buyer has less information about the thing sold. Ang mas nakakaalam ng thing is the seller. So the buyer must be aware of any defects thereon because there is information asymmetry. So the buyer must be aware. But this is embodied in the old civil code. What we have now is the new civil code. However, there are still rules under the civil code, new civil code, that the caveat emptor may be applied. Okay? Like when example you are buying a land with torrents title, okay? You have to, as a buyer, you have to exercise caveat emptor. You go to the register of deeds, you look at the title, if it is already sold, mortgage, or posted as a bail sa court, and such other encumbrances sa likod ng title na nasa register of deeds. Nakasulat yan doon lahat. So if you are buying a titled land, you have to exercise caveat emptor to make sure that there are no defects on that land you are buying. Now, under the new civil code, what is embodied is actually the caveat venditor, or let the seller beware. Why? Because the seller cannot just sell anything, because he has to be aware of the implied warranties, that whenever these warranties are not followed, then the buyer can go after him in a court of law. So this was adopted under the new civil code. The vendor is liable to the vendee for violations of the warranties. So yung vendor na ang mag-beware na he must be careful not to breach the warranties, or else the creditor, the buyer can go after the seller. Especially now that there are protection consumer rights laws, particularly the Public Act 1794, the Consumer Act of the Philippines, which mandates that there must be fair, honest, and equitable relations among consumer transactions. Okay, the consumers are actually protected under this law from against unfair and unconscionable sales acts and practices that the seller may be guilty of. So, mas mag-beware na ngayon ang vendors, venditors, because of these developments in law. Accidental elements. Okay. So, the contract of sales has essential requisites, the COC, consent, object, consideration. It also has natural elements, the warranties, the implied warranties. And number 3, it has also accidental elements. These accidental elements are not part of the contract, but they become accidental elements because the parties agreed, stipulate on these things. So if these are not stipulated, these accidental elements, these are not agreed upon, then this is not part of the contract of sale. So accidental elements are those stipulations, agreement made by the party, like conditions, interest, penalty, time of payment, time and place of delivery. So accidental elements. Two kinds of contract of sale. The law says it is absolute sale and conditional sale. So absolute sale is not subject to any condition, of course, and whenever there is delivery, then the ownership is also passed in from the seller to the buyer. Absolutely. So conditional sale, of course, there are conditions. Okay. Then the delivery of the thing does not transfer ownership until the condition is fulfilled. Take note, class. Even if the thing is already delivered, the ownership is not transferred for as long as the condition is not fulfilled. However, when the condition is fulfilled, then ownership will be transferred without any other further act. As long as the condition is fulfilled, then there is no other thing to be made, because the ownership will be transferred upon the happening of the condition. The law only states these two contract of sales, but somewhere in the civil code and other laws and decisions of the Supreme Court, you also have to distinguish absolute contract of sale, or sometimes only called contract of sale. Pareha lang yan. Pag sinabing contract of sale, class, it is an absolute sale. So absolute no conditions, ownership is transferred upon delivery. The conditional sale is subject to certain conditions, and the happening of the condition, the sale becomes absolute. Alam na natin dito. And so aside from those two, there is also what we call a contract of sale. Contract to sell, I mean. Okay. This is confusing to students because a contract to sell is just like a contract of sale. But take note that these are two different matters, two different concepts. Okay. We have been discussing contract of sale, but sometimes to confuse the students, they will ask this in the board exam. Okay, this is what we call the contract to sell. Just like contract of sale, this is a bilateral contract, meaning there are two parties, the prospective seller and the prospective buyer. Prospective because there is yet no sale. They agree, the prospective seller agree to sell the property to the prospective buyer, but he reserves the ownership of the thing even if it is delivered. Okay, and the prospective buyer promises to pay the price later. Okay, o sabi mo, parang ano sir, parang conditional sale. Hindi rin siya conditional sale. Because a contract of sale, okay, the prospective seller, okay, commits to sell the property to the prospective buyer, and the prospective buyer promises to buy the thing. And the ownership is reserved by the buyer, by the seller, until the buyer will have paid the full amount of the price. Ang kaibahan nito sa conditional sale, sa conditional sale is when the condition happens, then there is already absolute sale. But in a contract to sell, upon the happening of the condition, which is the purchase payment of the full payment of the price, a subsequent act is still needed to transfer ownership of the thing. Sa conditional sale class, kapag nangyari ang condition, there is no other act to be performed because the sale becomes absolute upon the condition, upon the happening of the condition. But the contract to sell, na ang condition dito is full payment of the price, okay? After payment of the price, okay, the seller needs to perform another act of transferring the ownership. For example, class, okay, nag-enter sila into contract to sell. So, nagkaroon sila ng agreement, nakasulat doon, gipanotaryo nila, nakatitle, contract to sell. Okay. Upon happening of the price, they will still need to again make another contract, which is transferring the ownership over the property. And ipanotaryo din nila ulit. So, there is a subsequent act to transfer ownership. Okay, what is important this here class na always remember is number one, prospective seller and prospective buyer ang tawag. Okay, the seller will sell, promise to sell, the buyer will promise to buy, but the deliverer of the thing will not transfer ownership until the price is fully paid. Okay, upon the payment of the full price, okay, they need to perform another act to transfer the ownership. Yun lang yun. This is a case of I give that you may give na contract. Okay. Which also appears to be like a contract of sale, but you will learn later on that this contract to sell, especially kung nasa ano ka, if you become an employee or an accountant of a subdivision company, real estate company, you will encounter this contract to sell. Okay. This is a case of I give that you may give. There is another one which is obviously different. I-discuss na lang din natin because this is also included in the civil code. Agency to sell. Now, agency to sell, a principal, the seller who is the principal party will contract another person called an agent and ask that agent to sell the property in behalf of the principal. Okay. This is the contract of agency na dapat kasama siya sa pagkatapos ng sales, pagkatapos ng contract of sales. This should include dapat the contract of agency. However, under the new syllabus, wala na ang contract of agency. Basta agency to sell class is I am the principal and I authorize you to be my agent and I authorize you to sell my property to other persons. Okay. Necessarily, I will give to you my property. But the transfer of the property from the principal to the agent is not considered transfer of ownership. Okay. Obviously, because the agent is not buying the property, he is only holding the property because he is authorized to sell it. Obvious ito class, madali lang itong agency to sell. Pero kailangan pa rin natin i-distinguish because sometimes they will also ask this board exam to confuse you. Because agency to sell sounds like a contract to sell. So you have to distinguish the four: absolute contract of sale, or sometimes only called contract of sale. Okay, but it is considered absolute kapag sinabi contract of sale. And then conditional sale, contract to sell, and agency to sell. Ito, review lang. Earnest money versus option money. We have discussed this in our obligations and contracts. Okay. So under Article 1482, earnest money is given in a contract of sale. It is considered part of the price and as a proof of perfection of the contract. So earnest money is actually parang first installment or parang show money to ensure that there will be a contract of sale. So earnest money is part of the price and it is a proof of the perfection of the contract. While option money, okay, yan. While option money, we have learned in our previous subject that there is such a thing as option contract, wherein a person is being given a time called a period, option period, and he paid for that, and that payment is called option money. For him to decide at that time, he will use that time or period, option period, within which to accept the offer. Okay? May offer sa kanya. Hindi pa siya decided to accept the offer. So, he paid for a certain amount of time within which to think about it. The payment is option money, called option money. It is payment for the option period, and it is not part of the payment of the sale in case naisip niya na i-accept yung offer. Okay. So, option money is not payment of the price but payment for the option period. Halimbawa, sir, you may ask, halimbawa, sir, the parties agreed that the option money will later on become part of the price if the after thinking about it during the option period, the prospective buyer will accept the offer, and then they agreed that the option money will be part of the price, then that is their prerogative, that is valid, and the option money will become earnest money if they agree. But you have to distinguish earnest money is part of the payment and it is a proof of the contract of sale, while option money is actually a payment for the option period so that the prospective buyer will have time to think about the offer. So that is option money. But if later on the parties agreed that the option money will become part of the price, then that will be converted into earnest money. So that is all for this slide. Thank you.